type of injury she suffered on September 20th, 2021.
This attack occurred.
We will show that no duty was owed by Ranger to the plaintiff to prevent the type of injury she suffered on September 20th, 2021.
This attack occurred on the early morning hours of September 19th and September 21st. Hannah apartment was broken into, and Hannah was brutally assaulted and raped for a period of 5 hours. She was choked.
Ranger argues that it did not have a duty to protect Ms. MATNEY from the type of injury she sustained, meaning from a sexual assault.
And Mr. Kelly, and it's in our brief, testified that it was Ranger's obligation to deter criminal conduct, to protect the residents, to protect the property, enforce the laws of the state of Texas and local municipality while providing security.
While I greatly sympathize with Ms. MATNEY, and I feel horrible about, what happened to her and what she's gone through, Ranger was not hired to protect her from an individual breaking in and assaulting her. That's plain in the language of the contract and the testimony of the parties. They were hired essentially to pass through the property a few times a night, as stated in the security agreement, check the common areas and amenities, and send reports back to Presidium so they could act on any suspicious or other notable observations.
The month that this happened, Your Honor, Mr. Jones had been admonished by his sergeant for Ranger.
Thank you, Judge, and may it please the court. My name is Michael White. I'm an attorney with Sheehy Ware, and I'm here on behalf of Ranger Protection Agency. We're here today for a hearing on our traditional and no evidence motions for summary judgment. Based upon the evidence in the record, our pleadings submitted to the court, and the arguments that I'm about to present today, we will show that no duty was owed by Ranger to the plaintiff to prevent the type of injury she suffered on September 20th, 2021. And further, that Ranger did not breach any of its contractual duties under its contract with Presidium and Edison Austin Investors pertaining to the incident that took place that night as well. Therefore, we will respectfully request that all claims against Ranger be dismissed from this action with prejudice. Before I get to our arguments, just a brief run through of the facts of this case. I won't belabor it. I know everything's been pled. But just for the sake of clarification today, the parties involved are Ms. MATNEY is the plaintiff, and she was a tenant at the Edison Apartments. Edison Austin Investors were the developer and owner of the property. Presidium Property Management, another named defendant, was the property manager for this property. And lastly, Ranger Protection Agency is a third-party security company contracted to work at the Edison, including on September 20th of 2021. The Edison Apartments is an apartment complex located at 4711 East Riverside Drive in Austin, Texas. And Ms. MATNEY signed a lease for Unit 1382 on August 27th of 2020 that ran through the date of incident into October of 2021. 4711 East Riverside Drive in Austin, Texas. And Ms. MATNEY signed a lease for Unit 1382 on August 27th of 2020 that ran through the date of incident into October of 2021 when she terminated her lease. I will share my screen briefly, if the court will allow.
Yes, you may.
This is Defendant's Exhibit C that was submitted with our pleading. This is the initial security service agreement that was entered into between Edison Apartments and Ranger Protection Agency. If I scroll down here to paragraph number 4, compensation, the Edison agreed to pay to Ranger $5,399 per month in exchange for service, which is detailed in paragraph subparagraph B, which is to provide mobile patrol up to 3 stops per night, 7 nights per week, and 40 hours a week of on-site uniform security services. This contract was entered into on February 14th of 2020. And then flipping over to Defense Exhibit D, which is the second security contract. This was entered into on August 1st of 2020 and superseded the prior security contract. And going down to the same area, paragraph number 3, compensation. You can see the compensation has been reduced to $999 per month with subparagraph B, service, mobile patrol up to 3 stops per night, 7 nights per week.
Well, that's kind of a big decrease, isn't it?
40 hours per week of on-site security having been removed from the contract, and it does not appear anywhere else in this contract. I'll stop sharing my screen. According to the testimony of Brian Kelly, the co-owner and secretary-treasurer of Ranger Security, the purpose of this arrangement was to enforce the rules and regulations of the apartment complex as outlined in the lease agreements provided by Presidium, which is Defense Exhibit E. This was echoed by Lucas Cantu, who was the community manager at the time of the incident, who said that Ranger was not viewed by Presidium at the time of the incident as a security company, but rather a courtesy patrol company, who stated that the function of Ranger was to ensure the common areas were in good shape, doors were locked, and suspicious or loitering people on the property were investigated and potentially escorted from the property. He made a point to say they were not there to guarantee the security of tenants or their property, and that's in Defense Exhibit F, are the excerpts of his deposition. And he went on to elaborate that the lease agreements, including the one entered into by Ms. MATNEY, contained explicit language disclaiming any express or implied warranties of security. Without belaboring the point too much, the incidents that give rise to this action, the main one was on September 20th, but it was preceded by another break-in of Ms. MATNEY's apartment on March 26th.
Okay, here's a report from one of the first instances, March. We know there was one about 10 days before this, March 18th. Maybe we should look at that one first. No, that's April. Okay, so this is April. This is after. Wait a minute. Yes, okay. So this is the initial application for a protective order that Hannah got against Adrian. I was out with my friends when Adrian suddenly approached me. He kept insisting on talking to me. I kept telling him that we had broken up and I did not want to talk to him. He kept insisting on talking to me and give him another chance. I sat and talked to him, but just kept wanting to get back together. He just wanted to get back together and insisted on me giving him another chance. I walked away and he started to follow me. I was crossing the street and Adrian grabbed me by my right arm, forcefully causing me pain. Adrian pulled me in front of him, facing him. Adrian was yelling in front of my face, and then he bit my chin. A bystander saw what happened and pepper sprayed Adrian. One of my friends saw what happened, and I used the opportunity to leave with my friend in the morning. When I arrived at my apartment, I saw that the police were there. Adrian had kicked down my door and contacted my mother looking for me. My mother had called the police, and I was issued an emergency protective order. See, here's the confusing thing, because again, it says on March 17th. On March 17th, Adrian found where I was with my friend and showed up. Suddenly, he was verbally aggressive. I told him that he needed to leave. He grabbed my phone, runs off, and slammed my phone on the ground, causing it to break. Adrian ran back inside and pushed my friend and started to throw rocks at the bartender. The police were called and Adrian was arrested. The next day, Adrian showed up at my door, banging to let him inside and get his stuff. So, does he stay in there? Is he living there? When Adrian came inside, he refused to leave for 4 hours. Adrian kept screaming at me, calling him a piece of shit, refusing to leave. Adrian started to punch his head, bang his head against the wall, and ran into the kitchen, grabbing a knife and pressing it against his skin, threatening to kill himself. I grabbed the knife from Adrian, and Adrian tried jumping off the balcony. I was able to drive Adrian to a friend's house to spend the night, and Adrian kept trying to jump out of the car. In the past, I've tried to break up with him multiple times, and Adrian just threatens to kill himself and hurt himself. Adrian was controlling of where I went, and I had to have my Snapchat location on. He would go through my phone, laptop, and social media to see who I was talking to. Adrian even started to work where I was working to keep track of what I was doing at work. I'm afraid that once the emergency protection order expires, that Adrian will come to my apartment and assault me. This was on March 17th, 2021. But this affidavit she didn't give until April 14th, 2021. So then, and then there's this. No. Yeah. On March 27th, Officer Morgan responded to blah, blah, blah. There were multiple officers already on the scene. A burglary call for service. The complainant was Carrie MATNEY, who is Hannah's mom. She reiterated to officer what the call text had originally advised, that Hannah has a violent and bipolar ex-boyfriend who had called her from Hannah's computer. Call text further indicated that the ex-boyfriend had told Carrie that he blacked out and could not find Hannah. Carrie believed that the ex-boyfriend may have done something to Hannah. When Officer Clinkscales arrived on scene, he was approaching the apartment when he came in contact with the ex-boyfriend in the hallway. He was identified as Adrian Watts. Adrian advised that he had spent the night at Hannah's apartment. Adrian went back to the apartment and pretended to put a code in the electronic keypad before opening it. However, Officer Klinkstill observed that Watts had actually just pressed lock button on the keypad prior to opening the door. Once the door was opened, Officer observed that the wooden door jamb was broken and that the deadbolt was extended in the lock position. I later observed that the door frame had been broken inwards, which is consistent with the door that had been kicked in. Watts advised Officer Klinkstill that he had kicked the door in. Later, Hannah arrived back at her apartment. He spoke with Hannah to determine what had occurred. Hannah advised that Watts and she had been in a dating relationship for 4 months. Hannah advised that on Thursday, March 18th, 2021, Watts had created disturbance while they were at a bar. That's what we just heard about. Hannah advised that she had broken up with him that night. Hannah stated that since then, he has tried to guilt trip her into dating him again. Hannah advised... Okay, so this is the same one we already went over. Yeah, like what a wacko. What a freaking wacko.
A man named Adrian Watts, who previously had dated Miss Matney, but they broke things off in February of 2021, and it was a pretty contentious breakup. They had an altercation at a bar on March 26th of 2021. Ms. Matney didn't feel safe returning to her apartment, with good reason, because Mr. Watts went to her apartment, kicked in the door, and waited for her to arrive. He was ultimately arrested for trespass, and Ms. Matney got a protective order against Mr. Watts. An important note is that this protective order was never provided to Ranger, nor were they ever informed of this break-in. They had no prior knowledge that this break-in from March 26th had ever taken place, nor were they ever notified that they should watch out for Mr. Watts or given a photo. They had no information of this break-in whatsoever. So then in September, on September 19th into the early morning hours of September 20th, Mr. Watts had attempted to regain communication with Miss Matney. She indicated she was not interested in speaking with him. He returned to the Edison apartments, kicked in her door again, and proceeded to sexually assault her for 5 hours. He was arrested the next day.
Five years.
On the date in question, Ranger was on duty under the second security agreement, Exhibit D, to perform up to 3 mobile patrols as dictated by the contract. I'll share my screen briefly again if the court will allow.
Yes, while you have the floor, you may share screen at any time.
Thank you, Judge. What I'm showing now is Defense Exhibit H, which is the daily site report submitted by Mr. Jones, who was the officer on duty that evening. Again, he was required to perform 3 mobile patrols of the property and create a daily report, such as the one I'm showing you. You can see he began his shift at 8:17 p.m. I won't read through every entry, but there was an entry at 8:51 p.m. for an asset check, 9:29, another asset check with a photo. At 10 p.m., another asset check with another photo. 11:02, another asset check. 11:34, same thing. 12:51, 1:37 a.m., 1:49 a.m., 2:29 a.m., 3:01 a.m., 3:33 a.m., and finally a shift ended at 4:46 a.m. In total, there were 10 asset checks and 1 positive contact with a tenant who, or we don't know if it's a tenant, but an individual who was in the swimming pool after hours. He told them that they needed to leave. This was all detailed in his report with photos. Shortly after the second break-in in September, Presidium terminated their contract with Ranger Security, but the termination was not for cause. The representatives of Presidium testified at their depositions that they were just going a different way, wanted to try out a different security company, and in fact, they had retained
Total
Ranger on
coincidence.
other properties managed by Presidium. Mr. Cantu, who I referenced earlier, testified that, to his understanding, Ranger had fulfilled all of their contractual duties, including the required number of mobile patrols, and they were not terminated for cause. J.J. Bailey, who was a regional manager for Presidium at the time, also testified that, to her knowledge, Ranger had fulfilled its contractual obligations to the Presidium, or I'm sorry, to Presidium as it pertains to the Edison apartments. Ranger argues that it did not have a duty to protect Ms. MATNEY from the type of injury she sustained, meaning from a sexual assault, under the terms of the contract. Defense relies on the ruling in Banzaf, I believe I'm pronouncing that correctly, the ADT, which is 28 Southwest 3rd 180. The court in that case held that, and I included some language in my pleading to this effect, but that, here we go. Plaintiff's claim of a contractual legal duty is premised on an assumption that ADT's being in the security business required it to protect Herman, that's the department store involved in that case, Herman's employees. That premise is too broad. ADT is in the business of providing security services for both property and employees, but it provides those services only pursuant to contracts with its customers. The customer selects the services for which it will pay. Plaintiff's argument would shift the responsibility for protection against crime without any contractual basis from law enforcement agencies to security companies. We are not aware of any case extending the duty of security companies beyond their contracts as suggested by plaintiffs, nor have plaintiffs cited any. ADT owed no duty to plaintiffs based on tort principles. Essentially, what the court in Banzaf ruled was that security companies only owe a duty based on what is explicitly in the security contract between themselves and the party they contract with. There is no extra contractual duty based in tort to prevent criminal activity, or as the court said, where was it? Apologize. That being in the security business required it to offer protection to individuals, in this case, meaning the tenants of the Edison. In their responsive pleading, plaintiff has pointed out private messages on a message board between Presidium and Ranger, in which Presidium is asking for Ranger guards to walk the entire property, walk the hallways, and patrol the entire property. These extra contractual communications do not create a new contractual duty upon Ranger, given that there was no extra consideration offered, nor was the written contract amended or supplemented to contain this language. Therefore, we can only go based on what is actually in the contract, which creates a duty upon Ranger to have its guards perform up to, not even necessarily at least, but up to 3 mobile patrols of the property per night. A reading of mobile patrol would indicate that means that a guard is just supposed to pass through the property in a patrol capacity, not necessarily get out of the car or whatever vehicle they're in and inspect every hallway, every common area, every amenity, every corner of the property. Rather, a mobile patrol, meaning mobile, passing through in a vehicle, to keep an eye out for suspicious activity.
This is Ranger Security's website, by the way. Check it out. Your safety is our priority. Includes security guards, bodyguards, and patrol. Where is it? Reliable protection. Armed security service. We know that they were armed. Today, countless threats might be posed in our businesses. These can come in the form of robbers, attacks, or even an accident. When these things happen, it's important to know there are people like armed guards you can rely or depend on. Ranger Security only deploys well-trained and professional armed officers. We will ensure they go through the appropriate background checks to ensure they're fit to carry firearms. Let's see. Residential security. If you're a residential developer or if you're in the residential business, it's important to think about the safety and protection of your residents. Having a security officer roaming around your residential area might be needed. This looks different than the last time I checked out this website, honestly. Trained personnel to handle a number of dangerous situations. There we go. Whether you're looking to find help regarding petty thieveries or break-ins, or allowing yourself and your staff to feel protected, can provide the help that you need. Stalkers, break-ins. Not only do we ensure that our clients get the necessary protection they need, The alarmingly significant growth in the need for security attributable to international and domestic terrorism and various criminal activities is something that our team is very much aware of, based on years of military service and training. Mhm. Oh,
Now, if the court determines mobile patrol is an ambiguous term, then you can look to the testimony of Brian Kelly, who is the managing partner, co-owner, and secretary treasurer of Ranger, who explained that a mobile patrol, as he teaches his guards, requires the guard to essentially perform 2 asset checks on the property and log it in the daily report, such as Defense Exhibit H, which I have presented to the court. An asset check means looking at an amenity like the pool or the barbecue pit or the dog park, or check the doors of the leasing office, things like that. That's how he instructs his officers to perform asset checks. And each mobile patrol, as he teaches it, requires 2 asset checks. This is the contractual duty placed upon Ranger based upon the contract between Ranger and Presidium. There is no extra contractual duty to prevent or deter criminal activity or to specifically protect tenants from criminal activity. That duty is never discussed in the contract, nor is it discussed in the contract that guards have to walk the entire property, check every hallway, check every entrance, check every lock. None of that is discussed in the actual contract itself. Now, in the responsive pleading, plaintiff also mentions how Ranger did not offer more services despite the high crime of the area, did not conduct crime surveys, did not present this information to Presidium in order to come up with additional security measures based upon the neighborhood that the Edison apartments were in. And again, these are all outside the scope of the contract. The contract between the parties does not require Ranger to provide Presidium with crime data to offer additional services beyond what Presidium is willing to pay for. And in fact, the 2 written contracts show that additional services were offered by Ranger, because when the first contract included 40 hours of on-site patrol, it was Presidium who decided they no longer wanted that service, so they removed it in order to pay less per month. But that service was offered by Ranger. So in terms of duty, Ranger is not asserting that absolutely no duty was owed by Ranger. We acknowledge that there is a duty based on the contract between Ranger and Presidium to conduct up to 3 mobile patrols per night of the property, which brings us to breach. Based upon the evidence in the record, there's no showing that Ranger breached their duty on the night of the break-in. Again, all that was required by Ranger that evening was to perform up to 3 mobile patrols per night. You can see from Exhibit H, the daily report, Mr. Jones was at the property at regular intervals that night. He made entries in his daily report, and any suspicious activity he saw, he included in his report, including at 3:33 a.m. asking a resident to leave the pool. Again, Ranger guards had no knowledge of who Mr. Watts was, that a previous break-in had taken place, that this was something they should have been looking out for. So first of all, there's no showing that a Ranger guard was even on site when Mr. Watts gained access to the property. And he wasn't required to, because again, based upon the 2 contracts, you can see that no guard was required to be on site at all times on the night and early morning hours of September 20th. And even if he was, there's no indication that Mr. Watts would have been deemed a suspicious person and that any action could have been taken. Again, Ranger guards are responsible for removing loiterers or suspicious people, but Mr. Watts had been on this property before,
Oh, they
and there's
are.
been no evidence presented that he forced entry or broke in to the exterior of the building. Now, we know he kicked the door into the private residence, but he was already in the building at that point. From the evidence that we've seen and the testimony we've heard, Mr. Jones completed what he was required to under the contract that evening. He completed his patrols, he made his report, he was compliant with his contract. And the testimony of the representatives from Presidium backed that up, in that they were satisfied with Ranger service, they believed they performed the required number of patrols through the property, and they were not released for cause. Simply put, just because plaintiff was the victim of a crime, and it was a horrible crime, and in no way do I mean to downplay the severity of what happened to Miss MATNEY, but just because a crime took place, that does not de facto mean that Ranger was in breach of a contractual duty. They did what they were contracted to do and what Presidium was paying them to do, and therefore they were not negligent in allowing this assault to occur. And for that reason, Ranger respectfully requests that all claims of negligence against them be dismissed with prejudice. To briefly touch upon two other claims raised by plaintiff against Ranger. For negligent hire, there's a claim of negligent hiring. Plaintiff has pointed out that Officer Jones had a prior felony on his record, which we don't dispute. But in order to succeed on a claim of negligent hiring, the plaintiff must show that the employee, meaning Officer Jones, committed a tortious act in order to succeed on that claim. There's been no such assertion that Officer Jones, on the evening of the break-in, committed a tortious act that would be actionable against him. He's not named as a defendant in this suit. And as I said, you can look at his report and see he did exactly what he was required to do that evening. Based on that alone, we believe that claim should be dismissed as well. And finally, the claim of premises liability. Plaintiff has asserted that Ranger was in control of the security of the Edison apartments and therefore could be found liable under a theory of premises liability. To that, I say that Presidium was in control of the security of the Edison, not Ranger. While Ranger had the uniformed guards, and all the assertions raised by plaintiff are true, that they got to choose which guards went to that property, how frequently during a night, they would perform their role patrols, they dictated the uniforms. That's all correct. However, Presidium was in control of which services to pay for and which services they did not want to pay for. They were in control of the security cameras on the premises. They were in control of repairing doors, locks, gates, other security devices on the property. Ranger had no control over that. Ranger was able to hire and fire security companies as they saw fit, which they terminated the contract with Ranger shortly after this and brought in another company. They could have done that at any time. They could have asked for crime survey data. They could have hired additional security companies. They could have brought back on-site guards. These are all the amount of security and how it was implemented is completely under the control of Presidium. Ranger simply furnished the guards as contracted, and under the control of the contract based upon what Presidium wanted and was willing to pay for. So for those reasons, we believe that Ranger was not in control as defined in the context of premises liability. And therefore, we ask that that claim be dismissed as well. So to sum up and try and simplify this as best I can, plaintiff's arguments essentially boil down to this. Ranger was hired to protect the tenants of the Edison from criminal activity. And since Ms. MATNEY was the victim of a crime while Ranger was under contract, they believe that Ranger is liable for these injuries. While I greatly sympathize with Ms. MATNEY, and I feel horrible about, what happened to her and what she's gone through, Ranger was not hired to protect her from an individual breaking in and assaulting her. That's plain in the language of the contract and the testimony of the parties. They were hired to essentially to pass through the property a few times a night, as stated in the security agreement, check the common areas and amenities, and send reports back to Presidium so they could act on any suspicious or other notable observations. They were fully compliant with their contractual obligations in the early morning hours of September 20th when the attack took place. Unfortunately, this was not able to prevent Mr. Watts from committing the horrible act he perpetrated that night, but that does not make Ranger negligent in this matter. For those reasons, and based upon all the pleadings and evidence in the record, Defendant Ranger respectfully requests the court that its traditional and no evidence motions for summary judgment be granted and all claims against Ranger be dismissed with prejudice. Thank you.
Okay. Mr. Bernal.
Thank you, Your Honor. Evidence regarding.
Okay.
Thank you, Your Honor.
Sure.
So, Mr. White has it appears he's gone back and forth between the contract and what essentially is parole evidence regarding an interpretation of the contract. I have a little more narrow analysis of the contract between Ranger and EDISON, which makes Ranger responsible in this case. As Mr. White said, this attack occurred on the early morning hours of September 19th and September 21st. Hannah's apartment was broken into, and Hannah was brutally assaulted and raped for a period of 5 hours. She was choked out several times to the point where she lost consciousness. The medical records, which we've attached, outline and illustrate in detail the petechiae, which are broken blood vessels in her eyes, where she was choked to the point of unconsciousness. She had a bloodied mouth, black eyes. It was a horrible assault. The assault was as a result of Mr. Watts breaking in the door. He broke the door frame of the door, as you can see there, and these are for demonstrative purposes. And it was so violent, it knocked the door frame completely off.
This is our motion we're hearing today.
Sorry, I meant to pause it.
Simplify this as best I can.
Particulars of crime in the area, which was the appropriate amount of, there's no question about that.
Okay.
Thank you, Your Honor.
Sure.
So,
Sorry.
Mr. White has it appears he's gone back and forth between the contract and what essentially is parole evidence regarding an interpretation of the contract. I have a little more narrow analysis of the contract between Ranger and EDISON, which makes Ranger responsible in this case. As Mr. White said, this attack occurred on the early morning hours of September 19th and September 21st. Hannah's apartment was broken into, and Hannah was brutally assaulted and raped for a period of 5 hours. She was choked out several times to the point where she lost consciousness. The medical records, which we've attached, outline and illustrate in detail the petechiae, which are broken blood vessels in her eyes, where she was choked to the point of unconsciousness. She had a bloodied mouth, black eyes. It was a horrible assault. The assault was as a result.
Okay, I wanted to look at this door.
Of Mr. Watts breaking in the door. He broke the door frame of the door, as you can see there, and these are for demonstrative purposes. And it was so violent, it knocked the door frame completely off of the door. This man was there to commit this crime. There's no question about that. As a little bit of background about the Edison Apartments, according to their corporate representative, was built on the west side of Austin in a high crime area, but the purpose of building it was a venture between a bunch of investors to flip this property. Their intent was to build these apartments, multi-family dwelling apartment complex on the west side, and to get it filled up 80-90% and then sell it. That was their job. That was what they were going to be. This was not going to be a long-term build, and Presidium was the management company that they hired. In February of 2020, as Mr. White indicated, Edison investors entered into a contract with Ranger Protection to provide security. Subsequently, that contract was nullified, and in August of 2020, they renegotiated another contract with Ranger. The contract that they entered into in February of 2020 had a dollar amount of $5,399 for mobile patrol, 40 hours a week with a standalone guard. At that time, Ranger had consulted with Edison and advised them that this was the appropriate amount of security. Now, keep in mind, Edison had not done one crime survey. Ranger had not done one crime survey. Ranger had not done one analysis of the crime in the area or the surrounding properties. They had done nothing to try to determine what the crime level was in that area. What they said was, we're going to charge this amount, and this is what we're going to provide. The terms of the agreement were to begin on the 14th day of 2020. An addendum to that agreement, Your Honor, was a specific outline of the guard assignments. And just generally, the guard assignments were going to be a standing guard for 8-hour time periods during patrol. This was going to be at the discretion of the officer in charge. In the following paragraph, they said they were going to have an 8-hour guard as directed by the officer in charge, leaving the entire security to the discretion of Ranger. And that's in the first contract. What's interesting at the very bottom, Your Honor, it says Ranger Protection Agency reserves the right to be acting in a security capacity on the property at all times during the duration of the agreement, without limitation. Without limitation. In August of 2020, Ranger negotiated a new contract with Edison. In that contract, Your Honor, the compensation went down by almost 80%. So at that time, Ranger entered into a contract which before they advised that $5,399 with all the standing guards and the mobile patrols were necessary, but yet 6 months later, without any crime analysis, without any discussion with Edison about the particulars of crime in the area, which there was a homeless encampment nearby. The crime had not gone down. There wasn't any evidence that they required less security. So Ranger undertook this contract knowing that 6 months before, this contract would have been inadequate because they were charging $5,399. Now they went down 80%. In the compensation paragraph, which is not a description of what they were supposed to be doing, this is just what they were being paid to do. It says mobile patrol up to 3 stops per night, 7 nights a week. Interestingly enough, in the guard assignments in this paragraph, where before in the $5,399 contract, they had all of these things that Ranger was supposed to be doing, and which was at the discretion of Ranger when they were going to do it and how they were going to do it. There's one sentence. It says Ranger Protection Agency reserves the right to be acting in a security capacity on the property at all times during the duration of this agreement. That means at all times. That is the contract. Now, Mr. White went into a lot of detail with the court about, well, these are the terms of the contract. This is the language of the contract. There's no ambiguity. Well, but then he went into parole evidence from Mr. Lucas, from Mr. Kelly, from Ms. Bailey, from the side agreements, all to prove what they were supposed to be doing. And the reason that Mr. White had to do that, Your Honor, is because it is not explicit in the contract. And in order for this court to construe this contract, okay, you look at the 4 corners of the contract, and where the contract is silent, then this court does not need to interpret the terms of the contract, but look at the evidence about the contract and what was done in order to determine its effect. And that's where we are here, right? We are here to try to determine the effect of the contract because the terms of the contract are silent. The what they were supposed to be doing on their stops, the hallways, the common areas, the doors, the pool, the dog park, the leasing office, the residence, the property. This contract is silent to all of that. But yet Mr. White tells us these are all the things that they were doing. And the reason he has to tell you that is because the contract is silent. So when Mr. White argues that there's no duty under the contract, then he's telling you there's no duty under the contract. We want you to read the 4 corners of the contract, Your Honor. But let me tell you what we were doing. Let me tell you what mobile patrol means. He had to define it for you. So I would submit to this court that duty does exist not only under the terms of the contract, but where the contract is silent. And that's where the evidence outside the contract that we're asking you to consider defines the contract. So in their motion, they talk about the negligent hiring and the premises liability and negligence. Their motion is only on duty. They spent their entire motion on duty. They have blurps where they say we weren't negligent or we didn't negligently hire, but there is no specific attack of the element of any of those causes of action. Their entire motion is centered on duty. And their claim is that there was no duty under the theory of negligence and under premises liability under the terms of the contract. And they rely heavily on this contract. What they don't contest is that Ms. MATNEY was an invitee and that Ranger, and that she was injured as a result of this assault. And so I think what the court is going to need to determine today is whether Ms. MATNEY, under the terms of the contract, which are silent about what they were supposed to do, and the evidence that give this contract the effect, whether Ms. MATNEY was in the class of persons that this contract was designed to protect. And for that, we have more than sufficient evidence, including the uncontroverted affidavit of our expert, Elizabeth Dunbar, who's a major in the United States Army and has extensive experience in security cases. So we go back to their contractual duty, which is what we talked about. The February 2020 contract entered into provided security for the Edison apartments at a certain time and place. That's what we're supposed to prove. You are supposed to provide security at a certain time and place. The August 2020 contract, a certain time and place. You were supposed to be there on the premises, providing security, including the night of the 19th and on the night of the 20th. What our expert has provided in her affidavit is the conduct and standards for security companies. And one of them is that when a security company undertakes to perform a contract for a residential property like this, they are required to do an investigation of the crime in the area, to do a crime survey, to do a crime analysis, and determine how much crime there was on and off the Edison property and within a 1 mile radius. Their own security guard, Alex Budenow, a Ranger security employee, testified that there was so much crime in the area that the police could not keep up. Jimmy Vaughn, also a Ranger security employee, testified that he considered Riverside to be a high crime area. This apartment complex was on Riverside. Our plaintiff's expert, Ms. Dunbar, in her affidavit, accounted for the fact that there were at least 295 crimes that occurred within a half-mile radius of the Edison apartments between January 2019 and September 2021. She broke that down by saying that these violent crimes, including 18 aggravated assaults, 29 robberies with a deadly weapon, and 2 murders, all within a half-mile radius of the Edison. So in order for the Edison to drop from $5,399 to $999 in an area this with this kind of crime, one would have to wonder if they didn't abrogate their duty. And I think White has all but said we did have some duty. We just don't think we had duty under the contract. So we have established that there's a contract. We established that Ranger was supposed to be providing security. And in that August agreement, they specifically say, while on duty at the protected property, each guard shall be furnished completely with their uniform, with their badge, officer ranger protection, an employee number by which a guard may be identified, all necessary equipment. This is not the Edison. This is Ranger. Edison is not providing security. They are also required to maintain licenses with the State Board of Private Investigators. Okay, each one of their officers is supposed to be maintaining a license, and they're supposed to be in legal compliance with the Private Security Act of the Texas Occupation Code. So these are all, this shows that Ranger was providing security under this contract and were required to have these qualifications. It doesn't say anything about Edison or Presidium providing the security. The corporate representative that we took was an officer by the name of Brian Kelly. When Mr. White tells you that all they were supposed to do was to maybe take some photographs and check some common areas, Mr. Kelly had a different take on that. And Mr. Kelly, and it's in our brief, testified that it was Ranger's obligation to deter criminal conduct, to protect the residents, to protect the property, enforce the laws of the state of Texas and local municipality while providing security. That is Mr. Kelly's own testimony about what they were supposed to do. He sets forth the duty. They were required to respond to noise disturbances, suspicious persons on the property, activities that violated property rules, anytime, day or night that could be reported. They also, Mr. Kelly also testified that Ranger reserved the right to effectuate arrests for several incidents or offenses under the penal code, including the Code of Criminal Procedure. And if Ranger witnessed someone violating one of these statutes, then Ranger had the right to arrest and enforce those rules and those laws. And Your Honor, when deposing Mr. Kelly, this is almost like a small police force. They have captains, they have majors, they have lieutenants, they have sergeants, and they have officers. They are all armed. Mr. Kelly showed up with 2 Glock pistols, with at least 3 magazines, 2 sets of handcuffs, and mace. I mean, he was armed. And I asked him in deposition, is this what you wear when you're on the property? And he said, yes. So this notion that Lucas Cantu said that they were there, you know, just kind of patrol is a misrepresentation. So we've established that Ranger was a security, that they had a contract. And now, in order to show what their responsibilities were, then the plaintiff is required to show the right of control. And the right of control that Ranger had over the property on September 19th and 20 was that they acted as the direct supervisor and controlled the security personnel at the Edison. They were the ones that were in charge with the Edison. I'm getting into the Banzoff case and the distinctions between there because they rely on that heavily in their brief. So this is evidence of control. This is undisputed. The affidavit of our expert says that they were under control. They should have provided post orders. They should have provided more delineated responsibilities, and they should have ensured that the areas where the residents live, the ingress and egress was not accessible, without a key fob. And we're going to talk about that in a second. The equipment that Ranger carried was equipment that was either assigned to them or they were authorized to obtain. And that would have been either their weapons or their mace or their patrol cars or whatever they were supposed to be using. Ranger, in both of their contracts, had unfettered discretion to pull officers off the Edison location and provide no security. In fact, I believe Mr. Budnar, and it's in our brief, testified, he says sometimes we couldn't make it to the Edison. Sometimes if we had too many properties, we couldn't make it to the Edison. Keep in mind, Your Honor, that the Edison was not the only property that Ranger had. They had at least 10 other properties that they were providing security for at this time. And so the way that they carried out their duties is where the negligence and the premises liability comes in because of their control and right of control. Edison and Presidium is not going to come forward and said, we control the security. In fact, they're going to say the complete opposite. We hired them. This is what they were supposed to be doing. The negligence under the contract was that they were charged with securing the premises on the 19th and 18th. The person that was supposed to be doing the security on the 20th was Kevin Jones. Kevin Jones was a convicted felon, and Kevin Jones should have never been hired by Ranger. In fact, Mr. Kelly said that he would not have been eligible to even have a license, and he didn't know how he had it. And they had this conviction in their file. And so when you look at these 8 or 10 snapshots that they have, these were proven up as a business record, but there is no affidavit attached by Mr. Jones or by anyone else saying that these are photographs that were actually taken by Mr. Jones. And our brief has contained in there, the month that this happened, Your Honor, Mr. Jones had been admonished by his sergeant for sitting in his car while APD was responding to a disturbance there at the Edison Apartments. And he was just sitting in his car. Mr. Jones is no longer with Ranger. The common area where the assailant gained injury was never checked by Mr. Jones. And the reason we know that is because the next morning, after Ms. MATNEY's assault, APD went directly to the door to the area, the building where she lived, that was only supposed to be accessed by a key fob or only supposed to be accessed with some security. And the APD jiggled and it went right open. Had Mr. Jones checked that on that night, he likely would have found it open on these 8 or 10 alleged visits and photographs that he made. Then he would have checked it and he would have known that that door was not properly secured. So when they say, well, there's no proximate cause, you can actually draw a straight line between Mr. Jones' conduct and Mr. Watts, the assailant, gaining entry into Ms. MATNEY's area. The testimony, and we have it in our brief, was that oftentimes Ranger and Edison would find homeless people in the hallways where Miss MATNEY and the other residents lived. Our position is they were in control of the premises at the time. They undertook a contract for a substantial reduction in remuneration to provide security. As I earlier said, that 6 months would not have been considered adequate. When the court reads the brief, the court is going to see in the briefs, the court is going to see a lot of emphasis that Mr. White, and he didn't really go into it in too much detail, but in his brief, there's a lot of emphasis on this Banshoff case. And this Banshoff case is easily distinguishable, and I'll set it out for the court. Banshoff involved Herman's sporting goods store that was apparently going out of business. What they did was they hired ADT to provide security surveillance after hours for the property when the employees were gone. Okay. In Hannah's case, and I've kind of outlined the distinctions between the two. Edison had no internal security, and they relied on Ranger to provide security guards. Herman had their own internal security. They had their own security people that were on staff. ADT provided no security guards. Ranger had the ability to effectuate arrests and enforce laws. In the Banshoff case, ADT after-hour alarm and surveillance was the only thing that they provided. They provided alarms and they provided cameras. And to get into the little more facts of it, what happened was after hours, one former employee of Herman's approached, like when they were closing, approached the Herman employees and told them, you need to reset the alarm to extend it further because you could extend the alarm so it wouldn't go off. They got in there, they robbed him, and unfortunately killed one of the employees and then injured a couple of the other ones. In that case, the court held that there was no duty under the contract and then outlined and listed these things that we have that are distinguished from our case. Ranger's contract was to protect the residents. If you read Mr. Kelly's deposition, he says, yes, our job would enforce the laws of the state of Texas and the local ordinance and protect the residents and the property. He says that should end the inquiry by this court on summary judgment. But if you compare that with ADT, ADT's contract was to protect the property of the sporting goods store. They offered additional protection and that was declined. There's no evidence whatsoever in this case, Your Honor, that anyone offered Edison or Presidium any additional protection when they were consummating the contract for the $999. There's no affidavit. There's no deposition testimony. This is Mr. White's conjecture about, well, we offered more before, but well, they didn't offer it. There's no evidence that they offered in the second one. Perhaps they should have. We might not be here. Ranger security was on the premises the night of the assault, or maybe they weren't. We don't know. I'd ask that this court look at the photographs that Mr. Jones allegedly took and his notes with the jaded eye, given the history of his employment with Ranger. In ADT, the defendant only had cameras. The Ranger security guard had loaded weapons. ADT had no discretion because it was surveillance only. In the contract itself for Ranger, it says that they can act in the capacity of security the entire time. Now, on defendant's no evidence motion for summary judgment, Your Honor, they did not provide us with legally sufficient notice on their motion for summary judgment. And I just raised this. We did respond to their no evidence motion for summary judgment, and we incorporated our traditional motion for summary judgment response and combined them. But, you know, the Holloway case is pretty clear. If you don't list each element of the plaintiff's cause of action to which you're asserting a defense, then it is not adequate notice. And this is what Ranger says as part of their no evidence motion for summary judgment. Defendant Ranger moves the court to dismiss all claims against it for lack of evidence necessary to support a claim against it. That's a prayer. That is not attacking each element of our causes of action in a no evidence motion for summary judgment. They don't attack duty. They don't attack proximate cause. They don't attack damages. They don't attack any of the elements of any of the cause of actions we assert. Then they go on to make a wholesale statement that basically says this: they have failed to present any evidence whatsoever that there was any negligence by any parties other than the criminal assailant, Adrian Watts, and the property manager, Presidium. that kind of brings up 2 points. Number one, it's not adequate notice to us, but woven in that statement is something very interesting. What Ranger is saying is, hey, Adrian Watts is negligent and Presidium is negligent, but we're not negligent. So how you can offer up a no evidence motion for summary judgment and claim that somebody else is negligent and you're not, kind of consumes your negligence, especially when you have a privity of contract with one of the defendants. So on that note, I would ask that the court deny their motion for no evidence motion for summary judgment because they've not adequately pled it and provided us with notice. So Hannah MATNEY, Your Honor, at the time of this incident, she had been raised by her parents, and it was a very strict religious environment for her. This was her first solo apartment. She was not a security expert, did not know
I'm
anything.
sorry. I can't hear you, Mr. Bernal.
I'm sorry.
Your sound is no longer working. I'm not sure what happened.
Okay. Can you hear me now, Your Honor?
Yes, I can.
Okay. I apologize. So, Ms. MATNEY was very, very naive. She had a former relationship with the assailant. We don't dispute that. This was her first solo apartment. She knew nothing about security. It was on the west side. And this was a high crime area. No one ever advised her of that. She was assaulted for 5 hours. We don't know where Mr. Jones was. At least 2 times, Your Honor, Hannah MATNEY broke out of her apartment. And this is in her affidavit. It's an uncontroverted affidavit. She broke out of her apartment, got out in the hallway, and was screaming for her life. She was screaming for her life, only to be dragged back in by her assailant and repeatedly assaulted again. If Ranger was indeed on the property these 10 times that Mr. White claims, at least Mr. Jones would have heard or had access to somebody. And she says that in her affidavit, and it's uncontroverted. This photograph is what Hannah MATNEY looked like the morning they took her before the sane nurse, which, as the court knows, is the sexual assault nurse examiner. The trauma from her asphyxiation is documented in the medical records that we produced. To this day, she still goes to therapy, knowing that in about 4.5 years, her assailant's going to get out. Okay. I don't know if Mr. Jones was on the property that day or that night. I do know that this security company took remuneration for security that they didn't provide. They couldn't provide. There's a huge question of fact. A lot of our evidence is uncontroverted. And once again, since Mr. White has taken it upon himself to introduce to the court other evidence, which he claims is extra contractual or parole, in order to define the terms, then I think that tells the court that the terms of the contract are silent and the court does need to consider all the evidence. And with that, we would respectfully request that the court deny defendant's motion, traditional motion for summary judgment, and no evidence motion for summary judgment. And I thank you today on behalf of Hannah MATNEY for the court's time.
Right. Thank you, Mr. Bernal. All right. And Mr. Clark, I presume you don't have anything to weigh in as far as this motion one way or the other.
Not at this moment, Your Honor. We have a summary judgment we filed yesterday that we're trying to get set before the DCO deadline of February 16th, and we're working with plaintiff counsel to do so. And ours is based on the timber walk requirements.
Okay. All right, thank you. Mr. White, it's your motion, so you get the final word, and it looks like you have 7 minutes remaining of your 30.
I will make it quick then. I just want to touch on a few points. Attorney Bernal has discussed at length the reduction in services and how this somehow falls as a responsibility of Ranger that the services were reduced. again, the Texas courts have been clear that security companies are only required to provide the services that the customer is willing to pay for. So not providing crime data, not urging them to keep the standing guard. I mean, these are all decisions that are up to Edison, not up to Ranger. Of course, Ranger would have liked to have kept the standing guard. It wasn't, like Attorney Bernal said, it was an 80% reduction in the money they were getting in every month. So it's against their interest to just get rid of that service. They're only required to provide the services that Edison is willing to pay for. And as of August 2020, they were only willing to pay for the mobile patrols. And so that's what was provided. In terms of whether the contract was silent as to what was required, the contract isn't silent. It does say 3 mobile patrols. Now, that could be open for some interpretation, but that does set at least a baseline of what is required. And it's up to, again, I emphasize up to 3 mobile patrols. It's not at least. So I disagree with the fact that it's silent entirely as to what is required of Ranger under the contract. As to the testimony of Brian Kelly, the crime deterrence and things of that nature, while deterrence of criminal activity can be a side effect of the presence of a uniformed security guard, prevention of crime is not mentioned in the contract. It's not, and it wasn't the intention of the parties when it was introduced. And Mr. Cantu, who was the community manager, said it was not their intention to bring on Ranger to prevent criminal activity. It was to enforce the rules and regulations of the apartment complex. So whether or not the actions of Ranger affected in or resulted in deterrence of criminal activity, it's beyond the scope of the contract, and so it is not a legal duty of Ranger, even if it was a side effect of their presence on the property. Attorney Bernal also mentioned that had he checked the door to Ms. Matney's building, that this would have prevented the break-in. Well, that's an unfounded claim because, again, Officer Jones had no way of, if the lock was not working, all he could have done is put it in his report. He had no authority to repair the door or to put anything in place to fix the lock. And so just if he had noted that the lock wasn't functioning properly, he would have put it in his report and an Edison employee would have addressed it the next morning. So there's no showing that simply failing to check whether or not the door locks were engaged was a proximate cause of the ultimate break-in. We also, well, and then as to the holding in Banshoff, we don't disagree that there are factual discrepancies, but the holding is pretty broad and the language is there for the court to interpret, but it refers to security companies generally, and is not qualified or limited by any of the factual specifics of that case. So we argue that the holding applies to the present case, as mentioned in our brief. Finally, Attorney Bernal also mentioned that and he calls into question whether Officer Jones was actually present on the property, and we put forth that the only evidence in the record shows that he was there at least 10 times, as indicated in his report. But the allegation that if he had been there 10 times, he would have heard something, he affirmatively would have heard something going on, is unfounded. The majority of the assault took place inside Ms. Matney's apartment. He had no access to the inside of her apartment, and there's no evidence that would have shown that he would have definitively heard something had he been there during the time of the assault. Again, just to reiterate, there's been a lot of discussion about the duties of Ranger, and in my opinion, it's pretty clear. They were required to do their mobile patrols as dictated in the contract. They perform those duties. There's no breach of any potential duty by Ranger, and for those reasons and all the reasons previously argued, we respectfully request that our motion be granted.
Okay. Thank you, counsel. I appreciate it. I'm going to take this motion under advisement because I did not have time to review the summary judgment record prior to today's hearing. So I'll take the time to do that. We all have a trial setting coming up in March.
Yes, ma'am. March the 18th.
Okay. I will endeavor to get you a response pretty quickly. I don't think it should